Welcome to NJAPM's second online mock civil mediation. Today's mediation will have a mediator and two parties represented by counsel. Our players today are Michelle Cresty, Suzanne English, Brad Ferenz, Andrew Smith, and Felicia Farber will be the mediator. I sent out the fact pattern last week. Using this fact pattern, the players will engage in a mock mediation for about 30 minutes. At the end of the mock mediation, you'll be able to ask questions, make comments, and so forth by raising your hand. Please remember to unmute yourself and lower your hand when you are finished. So with that, Felicia, it's yours.
Thank you, Carl. Welcome back. Happy New Year to everybody. As you know, this is our second mediation together. It's been quite a while since our first, and there's been some changes. So I'd like to take this opportunity to summarize what's happened to date. At our first mediation, Michelle appeared pro se, and she expressed her desire to try to resolve her claims without a lawsuit. She told us how she worked for the Gardens House of Clean in sales and customer service for 7 years. And because of the coronavirus pandemic, the company switched to remote operations in March of 2020. She said that during the remote months working at home, her productivity was extremely high, up 300%. And she did not want to return to work in person in June 2020, but she was told she had to in order to keep her job. The company promised her it would put safety precautions in place and made her sign a voluntary waiver. She told us that 10 days after returning to work, she contracted COVID-19 from the bookkeeper, and she became really sick, and she gave COVID to her husband, and he became even sicker and required long-term hospitalization, and she gave it to her father, who died from the disease. Suzanne Garden, the president and operations manager of the Gardens House of Clean, told us that she started the company 25 years ago with her husband, who's the co-owner and chemist. He formulates new products, and they're a small company that manufactures environmentally friendly hand sanitizers, disinfectants, and cleaning products. She and her attorney, Brad, related that they followed the governor's orders and state guidelines to the letter and did utilize protective measures for their workers. They also said that given the nature of Michelle's work in customer service and sales, they needed her back on the premises, and they expressed some concerns about Michelle's performance working from home. We had a very productive mediation session where everyone got to talk about what happened in the situation and express their positions. And at the end of our session, we started to clear up some misunderstandings and discuss settlement options, but we ran out of time. So in particular, when Michelle left off, she conveyed a demand of $10 million, but for mediation, she said that she would accept $3 million. Since that time, Michelle did retain counsel, and Andrew is with her today as her attorney. He's also filed a lawsuit on her behalf, seeking damages for the health consequences she and her husband suffered, and for the loss of her father, for back pay and benefits. I spoke with all of you after that last mediation, and both sides requested this opportunity to meet again jointly and to each make a statement. Andrew, I'm going to start with you, and I ask that everyone please mute your microphones while he's talking and during the mediation while somebody else is talking, because that will eliminate background noise, and then we could hear what the person is saying. Remember how difficult it was the last time to hear one another when there were interruptions and people were talking over one another. So please keep that in mind today. When one person is speaking, you'll each have your turn, and we don't want to run into the same difficulty. I want you each to be an active participant today, and we need to be able to hear you. So Andrew, please go ahead.
First, Ms. Farber, thank you for serving as the facilitator for this question, and definitely my client and I are appreciative of all parties getting together to see if we can work out a resolution. I understand from the previous time that the parties did meet and my client met pro se, in an attempt to resolve the case that is now before us. As I review the case that I shared with my client, I understand there are a number of issues, and I'm very concerned with what has transpired. I see a lot of people issues. My client was definitely treated unfairly through this process. I also see not only my client being treated unfairly, but definitely the impact of the situation has caused problems with her father. He passed, and that's very unfortunate. Also, sad to say, her husband also contracted the COVID virus, and that's very disappointing to hear that too. As a result of the company not following the guidelines directed by the state, that the company has really failed to adhere to a lot of state policies and guidelines. So those are very disappointing, a major concern to my client and to myself. And I'm sure at one level, perhaps to the customer to a certain extent also. And so not only are there the people issues, my client, her father passing, her husband, she also has a daughter that was being taken care of by her father. That's an issue too. So there are a lot of issues on the people side, but not only the people side, there are process issues that we're concerned with also, and that the company failed to adhere to the state guidelines. The company knew when it had its employees to come back to work that it failed to set up proper procedures, proper safeguard measures, and we should not be here. We should not be in this situation. If the company had done what it should have done, we would not be here. And so I understand from the case that my client put forth $10 million, and I just like to hold that in our back pocket. Again, for this section, we are willing to work at the $3 million mark to see if we can resolve this case. Again, I see a lot of concerns with what the company has done, and very, very problematic. It's so ironic that the company has the name Garden House of Clean, and these are the products that they produce to help protect the public, but yet it failed to protect my client. And also, it appears not only my client, but maybe that work environment is very challenging also. So again, we're here to work with the other side to see if we can reach a resolution. So that's our position, and that's our concern.
Thank you very much, Andrew. Now I'd like to hear from Brad or Suzanne. You both expressed a desire to make a statement jointly today as well.
Well, I'd like to start, if I might. And first of all, I know that on behalf of myself and Suzanne, I want to say to Michelle, it's a tragedy what happened to you. You have a long-standing relationship with the family. It's a family-owned company.
Thank you for saying that.
And they feel terrible about what's happened to you. But I also have to say it wasn't us. As you well know, this company takes the health and welfare of its employees very, very carefully and very seriously. And as a matter of fact, we don't believe that you got, unfortunately, the COVID from us, because you know that the governor came out with guidelines. You know, those guidelines were followed scrupulously. You also know that we have videotape, and we discussed this the last time, because much of what is done inside is videotape. We have a production line, and on that production line, we have a video to make sure that everything's being done appropriately, that the bottles are being filled appropriately. We have a creation line where there's a chemist, and the husband in this matter, and he's videotaped at all times. So, and we have examples of you not wearing.
Whoa. What does production have anything to do with me? I'm not in production. Like, well, why are you bringing this up? What's that got to do with anything?
I think that's a good question, and I think the reason I bring it up is really kind of very simple. I want to explain to you that while we are empathetic and understand, we don't think we have any cause of action, because we don't think we're responsible, because we have proof that everybody in the company followed all the guidelines at all times. And now, while I understand you got COVID, we have no idea what you did outside the company. We have no idea what you did on your days off and the days you were supposed to be in the company.
You don't need video of me. I'm not in
Okay, Michelle, please extend the courtesy to Brad to let him
finish.
finish.
You're saying things that aren't true.
Okay, Michelle, I'm going to give you the opportunity to speak afterwards, but everybody allowed your attorney to speak interrupted, and we're going to extend the same courtesy. So please do that. Okay, thank you.
Well, I have to tell you that while I understand that we'd like to resolve this stuff, speaking for Suzanne and myself, I don't know that it can be resolved. The idea of a $3 million verdict, a $3 million demand, much less a $10 million demand from a family-owned company that started 25 years ago and built itself up to a decent little company, is kind of, crazy. The company just will go out of existence, and you'll get, frankly, nothing. So what I'd like to do, if I can, is I'd like to sit down and talk to Andrew about working this stuff out, and he can speak to Michelle, because I know she's got a personal interest in this. I'd like to speak to somebody who's objective, somebody who understands the law, understands what a jury is going to do, because if this is taken to a jury under all the conditions that I see, it may be no cause, because she's got significant proof issues. And as an emotional being, and as I'm sure Michelle is, I think I'd like her to ask, and I'd ask her to rely on counsel, not to rely on how she feels, but rely on how counsel objectively sees what's going to happen, with the possibility of what's going to happen. We would like to make her whole, at least in terms of what we can do, but we can't even talk about $1 million verdict. There's just no money in the till. It just can't be done. And if that's where we are, let me talk to Andrew, let me get it done, and let's move on.
Well, thank you, Brad. And Michelle did listen to everything that transpired at the first session, and she did, in fact, understand her situation and go out and retain counsel for some of the very reasons that you've expressed. So thank you for that. And
if I may, just a brief comment, I've tried to be as polite as possible, and I will continue to proceed accordingly, since it's a mediation session. But some of the things that my adversary just said concerns me. He, on the one hand, said he wants to make my client whole, and we appreciate that, and that's why we're here, to make her whole. I think that's very important. That's why we're here. But he also said some concerns that we have a tape. My client works in the sales avenue. She has to be on the phone. She has to make money for the company. Without my client, without the sales, there would be no company. You can produce all the products you want, but if you don't have a sales funnel, if you don't have a sales outlet, my client by default has to talk to people. And so that environment should have been especially safe for my client, and it wasn't. Also, I have no problem with taking this to a jury, because I know what's going on. We all know what's going on with this state of COVID that we're experiencing. Everyone is concerned. Everyone is challenged. You have to wear a mask. You have to protect yourself. Even the jury will understand.
Can I thought I was going to get a chance to talk.
Michelle, please, during this statement period where we decided everyone would meet together jointly, and we are going to go into our breakouts exactly like we did last time, and you will have the opportunity to speak as much as you would like. But right now, we're giving this opportunity to the attorneys before we do that. So please, your attorney is speaking. You definitely don't want to interrupt him.
Yeah, I was just going to say the jury is very important. They understand this case. Even just hearing the word COVID, they will understand this case, and they will understand my client's position. Also, the other point, I can appreciate my client really want to express her concern, because she's been impacted heavily. First class, her husband is sick, still sick. Michelle is still going through a lot of challenging situations. Her father passed away. I mean,
Andrew, nobody is in any
very important case for us.
Wait a minute. Stop.
Wait, hold on. I just want to, before you go, Brad, let's keep this, I don't want this to be argumentative, because
Alicia, I'm very tired about hearing about the injuries. I do not in any way quarrel with the pain and suffering that Michelle has gone through. It's just not us. Okay. I don't want to use the word windfall because it's offensive. So I'm not going to use the word windfall. But the reality is, I believe a jury will see through this. Andrew does not. So the bottom line is, if we're still talking about millions of dollars, it's not happening. We don't have it. We just don't have it.
Understood. Thank you. And we did start to talk about the numbers at the end of our last session, and we did leave on a positive note. So I would like to pick up on that and continue those discussions. And part of my job is to speak to each side, and to talk about the issues that you and Andrew have just raised here, Brad. So I would like to do that now. And I would like to start with Andrew and Michelle. So I'm going to ask that you, Brad, and your client, Suzanne, step out of the room for a few moments, and I will be back with you shortly. Thank you. Oh, wait, hold on. Where did Suzanne go? Before you go, oh, I did have another thing I wanted your client to hear. Okay, thank you. What I wanted to say is while I am meeting with Michelle and Andrew, I'm asking you to please use this time productively, because there's been a lot that's been said. There might be, think about what more information you might need at this point in talking about potential solutions here. And remember that we are stepping out of the litigation forum right now. We are in the mediation process, which is very, very different. So, I allowed you all to speak, and it got a little bit argumentative, but in mediation, in this forum, we're here to try and work out a resolution together. So instead of, arguing about the case, I'd like you to kind of switch your mindset to working collaboratively. Think about what could be a fair and reasonable solution that might work for everybody. Think about being creative in a way that you don't get to do in court, and what might be a fair and reasonable outcome for, globally for everybody. And also, while I'm gone, Suzanne and Brad, think about how I, as a mediator, might be able to best help you to get to where you want to be. Okay, so please give me a couple of minutes with Michelle and Andrew, and I will be back with you shortly. So we're going to black out your screens. Thank you.
We look forward to working with you.
Thank you. Please, Brad, black out your screen. You're in a breakout room for purposes of our, thank you. Okay. So Michelle and Andrew, it is just us. You heard their position, and that is something that we touched on last time. And I don't know, Andrew, if you've discussed with Michelle, the legal challenges that there might be in this case, such as Brad was raising about causation. Michelle, that means, can you prove your case? Can you connect you contracting COVID to the measures that this company did or did not take? Can you connect your transmission of the disease to them? Can you prove that? So
we have not yet spoken with the bookkeeper to get her position to depose her, but I believe what, of course, has been said that my client, Michelle, did contract the COVID through the bookkeeper, and the bookkeeper, of course, was not wearing a mask. So we believe we can connect the dots from that vantage point. But definitely, we are open to working with the other side to see if we can reach a reasonable, meaningful resolution, but it has to really take into account of the harm that my client has been dealt with. Her father, unfortunately, passed. Her husband is still sick, and so there are a lot of issues that she's facing right now.
Yeah, and I don't know why they keep saying they don't have money. They have insurance, so I don't know where this money thing is coming up. So, I'm not asking them to take money out of their pocket. I mean, I'm not looking to bankrupt anybody. I just want my family to be put back. We'll never be put back where we were. It's impossible. But at least to put us back on at least a decent footing. And I'm not looking to bankrupt their company. I mean, they failed me, but they have insurance, and that's what it's for. And I'm entitled to my piece of it.
All right, so Michelle, what you need to understand here is that, you obviously feel that you were damaged, and you would.
I was damaged. My husband was damaged. My child was damaged, and my father was damaged. We were all damaged.
By you, I'm talking about your entire family, extended out to them. But here's the thing. Even though you are sitting here right now with very valid points, as you heard, the other side believes that they have very valid points too, and they're saying them with just as strong conviction as you are. And when you leave mediation and you go into litigation, back into a courtroom, now you're leaving up the decision of what's going to happen what, if anything, that you might be compensated is going to be up to a bunch of strangers. You have absolutely no control. And if you have anybody who thinks the way Suzanne and her attorney, Brad, do, that, you know what, this is a pandemic we're in. COVID is everywhere, and we don't know what you were doing. We don't know if your husband gave it to you. So if you were listening to what they were saying, you know, this is very, very hard to prove. This is a whole new body of law right now. We really don't have case precedent. So it's hard to say what might happen. And
well, if I got a chance to go and tell.
Let me finish, please, Michelle. I just want to point out that it is possible, if you go into court, that a judge or jury might be believing what Brad and Suzanne are telling you, that it didn't come from them, and therefore you could end up with nothing. So you have to think about, you know, the millions that you're asking for versus hiring Andrew, you know, paying for expenses, going through this whole, you know, emotional process, because it could take a long time before you go through the discovery process and get to a verdict at a trial. And then what if you were to end up with nothing? And that's one of the reasons why people settle their cases, and most of cases do settle. It's in the high 90%, like 97, 98% of cases settle for that reason, because there is a possibility, because this is so new, this COVID situation, that you could end up with nothing. If they say that is true, you could not prove that you in fact got it from here. Even if, Andrew, you did depose the bookkeeper, you know, you would have to get an epidemiologist. Would they be able to pinpoint that transmission contact? You know,
I hear you. I just have one question. Michelle, if you could just run through the scenario when you left the company. I understand that it was mutually separation, but if you can just kind of walk us through that day. I was just somewhat concerned about, really, was you kind of forced out, or did you actually, was there a true mutual separation? You just go through what happened that day. I just want to, for the mediator's sake.
Oh, well, they gave me no choice. I had to leave because the workplace was unsafe. I could not accommodate to take care of my child any longer. So I had to leave. I mean, unfortunately, so that's the thing. This story is just so long, but there's so many important details. If I got a chance to tell my whole story to a judge and a jury, there's no way they would not believe me. You're right, this is COVID. They would understand how poorly I was treated, how poorly my family was treated. So I don't buy it that if they got to tell their side, they would win. If I get to a judge and a jury, I can't wait. I can't wait to tell my whole story, because they're definitely going to believe me.
Michelle,
but now here I am.
Michelle, I'm sorry to interrupt, but can you guarantee that? Is it possible that it might
common
be
sense
another
says
way?
that I would win. Common sense says that I would win.
Is it
and
possible,
by the way,
but Michelle, you've got to think, is it possible that might not be the case? Is it 100%?
I don't know, but right now.
Right, exactly. You don't know. And for the interest of time, I'm sorry, I have to move this along.
So, yeah, but I mean, here we are. So now I'm not making any money. I have no money coming in. I have no health insurance. We're paying an exorbitant amount on Cobra to pay for health insurance. So I was treated shabbily. I was treated poorly, basically kicked to the curb. And now I have no money coming in other than unemployment. And from that, we're using our savings to continue Cobra to pay our medical treatment. So this is really, talk about bankruptcy. We're going to go bankrupt.
So one of the things,
my concern, there could be a SEPA claim here also, because if she saw something that the company was doing incorrectly, and she was in the process of reporting this, so not only do we have the COVID issue, but there's a SEPA claim in that she was forced out because of what she saw the company, that they were not following government guidelines. So there's multiple claims that we can actually bring forth. So it's not only the COVID claim, there's other claims that we could bring into this matter also. So, but again,
did you say that? Is that, Andrew, is that in your complaint?
Well, we can definitely amend. Based on what I'm hearing, because that's why I wanted to talk to my client even further. Again, she just hired me, and we just got together to really file this claim very timely. but we just want to make sure that all the claims are put forth. And we are very concerned about the secret claim also, in that she saw what happened. She was not a mutual separation, but she was really kind of forced out. So we're concerned with all the claims that we could bring forth. But again,
Right, thank you, Andrew. You also understand, some of the legal obstacles, that have been raised. So for mediation purposes today, I'd like you both to come up with some type of offer that I can that I could go and take to the other side with whatever message that you would like to get us going so that we could try to resolve this. Because Michelle, I understand your financial predicament, and this could take a very long time, and everything that you've stated will continue down that path and will get worse for you financially until this is resolved. This is a chance for you to resolve it today. And also, like you said, you admitted that there is risk. You just don't know, what you would like to happen at a trial, but you don't know what will happen. So in order to eliminate that risk and in order to get you a resolution right away, please, work with your attorney and try and come up with something that you think will wash with the other side. For instance, Michelle, I don't know if you would consider, if they wanted you, going back to this company. Is that a possibility?
Michelle, we did talk about that briefly. I'd just like to get your thoughts on that. I understand that you've been with the company 7 years. You definitely have the skill sets. Definitely you have the background. You can hit the ground running again if you so choose. But I'd just like you to explore that just a bit further. I know you kind of expressed some concern about the company, but supposedly it was mutual. I just want to hear your thoughts on that. Would you be open to going back to the company, first of all?
Are they going to pay me money for everything that's already happened?
Well, that's what we're working on.
That would be a very important consideration. If you get her job back, but yet, again, she still lost her father. Her husband is still sick, and a lot of issues are still taking place. So I think Michelle may be open to, at least I would consider it also, going back to the employment under proper conditions, but yet still receiving monies to compensate her for what she has been challenged with, the damages that she has incurred and continue to incur.
And Andrew, what would those, if I bring this back to Suzanne and Brad, what would those money damages be along with, reemployment?
Well, one of the things we have to understand is, what is the insurance policy? I mean, I made the request to the insurance. I made the request to opposing counsel, have yet to receive anything. If you can really capture what the policy is like, then that would be at least a door opener, that we can at least have that dialogue to see what the numbers actually look like.
Okay, so I'm going to go and do that right now so that we could continue and be productive on our end when I get you that information. So please black out your screens and I will get back to you shortly. All right, I ask that Suzanne and Brad please return to the mediation. Okay, thank you both. I had the opportunity to speak with plaintiff and her new counsel, and we talked about some of the things that you raised. As you know, Brad, there is no perfect case. And Suzanne, as strongly as you expressed your position last time, so did Michelle continue. However, you did say at our first mediation, we did talk about the fact that you thought she was a good employee, and a potential solution to this dispute you're having would be for her to return to the company. And I did discuss that with her, and that is something that she would be open to. So we have some good news on that front. They do have a question, however, about what the insurance policy is. So
let me ask you a question, Suzanne, if I could. Suzanne, look,
yeah.
I don't know that I have a problem with her coming back to your company, but is there a way she can work at home remotely on sales, give her a reduction in actual salary, maybe an increase in percentages in terms of what she sells, so she'll get less than her base, but more if she sells? Because I understand you had some trouble with her towards the end of her employment. She wasn't really working to her potential. But if you gave her less of a base and you paid her more of a percentage of what she sells,
Right.
she can make more money. She'd be out of your hair. She'd be
Yeah.
somebody didn't have to come into work, and she'd be at home working, which she could take care of their
Well,
husband.
it would be on her. She would she's not guaranteed money unless she actually does the work.
And there you
Okay,
wouldn't care.
so-
She knows all the customers. You do a non-compete contract so she can't go elsewhere.
Yeah, well, she already has a non-compete.
You know.
All right, Brad, I don't know if this would be the time to talk about reducing her salary right now.
Well, I don't. Why not? I mean, the reality is what we're saying here is, look, we'll give you a job back, and you can work at home. Okay.
Well, this is just one condition that we talked about, and she didn't commit to it. We talked about possibilities, but one of the things that she is most concerned about are what would be her monetary damages here. What would you give her for the losses that she has suffered to her health and to her family? So, you know, that's really...
We don't think we're responsible. We think that causation is a real issue. We think that this is basically, I don't want to say gold digger. I don't want to say somebody who's looking for a windfall. It's a tragedy what she went through. But when you ask what kind of monetary damages, she's being offered, unless I'm wrong, Suzanne, and you correct me, the opportunity to make more money, the opportunity to work from home, the opportunity to have medical coverage, the opportunity to start all over again, if you will, and have income coming in. And given what's going on and the need for the type of products that Suzanne's company produces, she'll be able to make more money, be more satisfied, and not have to ever worry about coming into work.
So Brad, now that she has counsel with Andrew, he did say that he intends to amend their claim in order to add a SEPA action. So he feels that she was wrongly treated here as a whistleblower, and that there could potentially be punitive damages, costs and attorney's fees, in addition to a high monetary award in her favor for SEPA. So yes, I part of my job is to talk to them about the causation issues, that this isn't so clear as they're saying. COVID cases litigated are new, you know, so we don't have legal precedent here, and you certainly don't want to be the first with what you're calling a windfall verdict. So it's really in everybody's best interest to see what we could do to try and resolve this. And one way to do that is to think about what would make her go away, you know, what would appease her. And so when I said to you, would that work with lowering her salary at this point, you know, we're talking about trying to make a lawsuit against you go away that could be very expensive, very protracted, and unknown outcome. Cases settle because of expense and exposure. It's going to cost a lot of money to defend, and exposure. You don't know how it's going to end up. And if there's a SEPA claim on top of it, if they can prove causation.
My law costs are covered by the insurance, but the $250's on me. And then, so I don't think a jury's going to ever agree with her. Everybody knows COVID's everywhere. How would you possibly prove that she got COVID at work? There's no way. I mean, she has a sad case. Of course, we feel sorry that her father died and that she's sick and her husband's sick. But that if you look around everywhere, this is happening to everyone.
And that is a very valid point.
So if I just give her money now, I'm out of pocket. I'm a small company. Everyone's like, oh, you must be doing so well because you're cleaning. Well, you know, our production costs and I'm exponentially.
Suzanne, listen to you hired me for a reason.
All right.
And not cheap.
Okay, so this is a very valid point. We're getting to where we...
The question without interruption, mediator. Suzanne, do you have any...
No, Brad, I'm sorry. Remember, we have to wrap this up at a certain point, so we're at that point.
Which is how much it's going to cost you to pursue this, and it might be cheaper to pay somebody else rather than paying me. I'm trying to get your money.
All right, and what... Yeah, so what I'm trying to do...
I just defer to my attorney because he's got my best.
I know we're at the end, but and I know that this is not part of the mediation. I'm speaking to everybody watching. The idea was to try and put some pressure on the client to get money by saying it's going to cost you $100,000 to litigate. So that's
right. So by stepping out of role, when I'm saying we have to wrap it up and I'm trying to interrupt here, it's for the purposes of this program that we're putting on. I normally wouldn't do that. But we did want to get to maybe more of a realistic type ending. So if we fast forward here, pretend we're 5 hours into it right now. So let's talk about potentially a final solution here. So pretend we've been mediating all day. So let's return to this.
I recommend to Suzanne a
Yes.
$200,000 lump sum payment, which will save her $50,000 on insurance costs because it's a $250 deductible. I would also recommend to her that she permit her to come back to work from home at the same salary and get even a higher percentage, like 2% as opposed to 1% of whatever gross sales she has over the 4-year period. That would be my recommendation to Suzanne.
Suzanne, thank you, Brad. Is that something I could convey to the other side?
I think that the 200 is high, honestly, because I mean, you know, I'm kind of in for a penny, in for a pound, and I'd like to see it lower than that, frankly.
But do you understand that they're looking at millions? They want to know what your insurance policy is. Is that something that also you could?
I think I'm being generous. I don't believe that. I think if they go in front of a jury, everyone knows that COVID is out there. Everybody's getting it. This is not something that you can trace to your work.
Right. Thank you. We've talked about this all day now, and your attorney is making a recommendation, and I want to know whether you authorize me to convey that.
I think the 200 is high. I'd like to go, and I mean,
what number are you satisfied with?
Well, like 100,000. I think that's being very generous.
It's not going to do it. It's not.
Okay, one of the things, right, thank you, Brad, I asked you earlier before we broke out is to think about what would be fair and reasonable and satisfy the other side the same way you want something that's fair and reasonable to make this go away, taking into account that exposure that's out there and a protracted lawsuit with the costs and expenses of that. So factor all of that in.
My legal fees are covered by my insurance. So, I mean, and I'm out, you know, like 200, 250, not a big difference, but I could be zero if I go to court. I think I'm in a better position.
But what's the other side? If it's not zero, if you go to court, what's the other side?
Well, I have 250 because that's my part.
No. What could a jury come back with if they feel bad for her with her health issues, her husband, and the loss of her father, if they were to listen to her and want to compensate her? If you had a sympathetic jury, what do you think?
I don't know, but I don't care because I'm at 250. So no matter what, my part is 250.
That's your deductible, but I have to go back to the other side now. So please, can you both give me a final package that I could relate to them?
Suzanne, my recommendation is that you offer 200. Let her come back.
But then she's going to come back and say 500. It's ridiculous. No.
Well, Suzanne, we've been doing this all day. We're at the final point right now. So
but I don't think you should go in with a 200 because if you go in with a 200, they're going to come back and want more than that.
Well, before, you know, they had gotten down to 500. So now.
Supposing we ask Felicia to go in, offer them 100, but tell her we will go up to 200.
That I'm agreeing. I just don't want to go right in and say, oh, here you go. This is it. Because then they're just going to come back and say, we went 500.
And are you good with offering her job back remotely? Maybe giving her a little kick on 2% as opposed to 1% commission. It doesn't hurt you.
Right.
It gives her an incentive to sell.
That's fine.
So you have an offer.
Okay. All right. Thank you both. And Suzanne, I'm not disagreeing with you. I'm just saying for breaking out of role again for purposes of today and showing our attendees, you know, getting to the end stage and final offer. So that's where we were at. But in a normal situation, yes, you never want to go in with your final numbers. So thank you. I'm going back to the other side. Please black out your screens. Andrew and Michelle, can you please return? All right, thank you. So we've been at this all day and now we're trying to wrap it up. We've got our final offers and demands we've been going back and forth with. So Michelle, the good news is that they do want you back and they will offer you a slight increase in salary and in your percentage of your compensation. So you would get 2% on your sales instead. Well, you know what, I'm sorry. I think,
am I getting any money?
Hold on. I think it might be your same salary. We discussed that back and forth, so forgive me on that. It's definitely they'll give you your salary, 2% and 1% on sales. You will work from home, so they're allowing you to work remotely, and they're offering you $100,000 to do that. There is, I could tell you, some movement there. I know that is, not something that, you're going to take lightly here. I know you were talking in the 7 figures, not even 6 figures, but keep in mind, as I said earlier in the mediation, these are starting discussion points. So what do you think of that? A monetary figure along with keeping your job, working remotely, increasing your sales
Well, the
percentage?
100,000 is insulting. That's an insulting amount of money to think that that's going to compensate me for the loss of my father and the disaster we've been suffering with my husband.
Yeah, I would be concerned with that too, because we have not explored how far the law will go, but we are concerned that with what has happened to our family members. And I'm not sure what the law is, but I'm open to exploring to see if there is maybe an indirect claim that could be brought directly by her father. It's something I'm checking into. So again, something I'm exploring. But for the purpose of this case, my client did say $100,000 really is a non-starter.
Yeah, Andrew, we've been sitting here all these hours. I'm about ready to leave. I've had it. Like I'm paying somebody at home, take care of my family, and now I'm just losing more money to be here. So I don't know about you, but I'm ready to go.
Okay,
Yeah,
I have to bring this to an end, and let's bring everybody back.
Okay.
Okay. So before I open this up to questions from our members, I have a couple of questions. Felicia. When Andrew was talking, Michelle started to talk and you cut her off. I was wondering why you cut her off when...
Because we're out of time, because of what we're doing today, because I had to wrap it up because we're out of time.
This was earlier. You were still pretty early on. But do you remember that, Michelle?
I do. And to tell you the truth, I would have done the same thing that Felicia did, because in fact, I probably would have asked Andrew if he wanted his client to be speaking, because I get very concerned when my own client speaks sua sponte and they may say something that I don't want them to say at all. This was, so I would have done exactly what Felicia would have done and just ask the client politely to talk. I mean, they have a lawyer there for a reason. And unless there was a specific, permission by her counsel to let her speak, I would have done the same thing that Felicia did.
Carl,
Okay.
I mean, she was
Now, Brad, when you were talking, you essentially told your client to be quiet, right?
And I also interrupted the mediator and said, give me time to speak to my client. And I was not permitted that time.
Okay. But that's what you would normally do.
Correct.
You do not ever want your client to talk.
That's not correct.
Okay.
But I do want at least initially the client to listen carefully. Then I like to go back to the client, figure out where they are before they say anything foolish.
Okay.
And
Felicia,
Carl, just from my vantage point, I was glad that Michelle was going to say something, because I was going to bring up the emotion. And the emotion was a leverage that I wanted to use also, that she's very emotional as far as what happened. And I wanted that to be brought forth also.
Okay. Now, Felicia, you agree that you don't want clients talking?
Excuse me?
Are you supportive of the attorneys essentially telling their clients, no, let me do all the talking?
You know what? When they have counsel, that's between them. But I do try and encourage. I want the clients to speak at my mediations, especially if there's something that's very personal, because unless they have that emotional release, they get out their negative thoughts and feelings. This is something that had a very traumatic impact on Michelle. And this was, traumatic for Suzanne too, as a small business owner, to have her employees, get COVID and one of the family members die. This is something that's horrible for everybody. So unless I can, let them get that emotional outlet so that they can talk rationally in a business sense about an outcome, that works through the business lens, and not not emotionally, then I'm not going to be able to shift their mindset and get them to look forward and get them to be positive and collaborate. So to me, part of this process is to engage them in the process. They need to be part of it. They need to feel that they're not stifled, that they have control and they're active participants in the process and the outcome.
So when Brad said to his client, please don't talk, why didn't you say something like, I would like to hear from Suzanne? I mean,
totally. My whole role in this was altered because of our time constraints. I feel like I've been like, the time monitor trying to move this along. So normally that would not happen. I absolutely want to hear from.
Okay.
But I think
another point. Go ahead, Michelle.
Oh, sorry. Just to clarify what I was saying was, I do think that it is important to have the actual litigants, people talk. I do think so that they get their quote unquote day in court. Because if they don't feel like they got their day in court, they're never going to feel like they got their side of the story out, and they'll never feel satisfied with the settlement. However,
there's a time.
Right, there's a time, and I think that has to be with the assistance of counsel, because what you don't want, and as a mediator, I'm very mindful of this, I don't want to sabotage any other lawyer's case either, because you don't want their client to be saying something that is contrary to their interests. So I think it's got to be like kind of delicate. Let them talk, let the litigants talk. That's important. That's why we do this, right? We tell everybody, put all your cards on the table, be open and honest. We tell them all those things, and I do mean it. But I think it has to be with the guidance of counsel, that they, in their own interest, that their emotions aren't going to carry them away and somehow, sink their battleship.
Right. Okay.
Judge is going to say something.
Now, I have one more question for Felicia before
you go, I got to say something very, very briefly. These folks have lawyers.
Yeah.
How dare any mediator go directly to the litigant without talking to the lawyer first? You say to that lawyer, may I speak to your litigant? You go through the lawyer. Yes, you want the litigant to be able to talk, to purge. But if you go directly to the litigant, in my opinion, without the lawyer, you minimize that lawyer's impact, and he may not be, or she may not be, as useful later in resolution. I think you've got to do that form over process. I think that process is very important. And
right, like Felicia said, there's a time and a place.
There's a time. And Carl, just to clarify, at the beginning when we all did speak jointly, that was for attorneys to be making the statements. So if you're saying I didn't let Michelle talk and you're referring to that time, that was why we reconvened jointly, because normally that would not happen.
Okay.
But I did that purposely, because you do get I did that purposely, and I didn't know that, but I did that because you do get parties that do that sit there and they're making faces and they're like jumping in and they're trying, so you have to say no, we have a process. And I think that was important. That's why Felicia was good, because she said, we have a process, we had ground rules, and this is what we did. So I think that she respectfully brought it back to the ground rules that were originally set. I did that intentionally. I didn't just...
Okay.
Now I have one question. We have to get over to the members. At one point, Felicia, you asked Andrew, can you prove that? Can you prove your case? And then after that, you said, you have a very hard case to prove. Is that something that you would normally do? That's very evaluative. Would you normally say something like that?
Yes.
Okay.
Yes.
Now let's open it up.
That's part of my job as the mediator, because they're going off on what's the policy. I want millions, and the other side is at zero. And you're talking about a situation where I pointed out there is no case precedent right now, and they have these grandiose visions of millions of dollars adding claims. They're out there in the stratosphere when they might not get off the ground. She might go through this, Michelle, with these high hopes of these millions and end up with zero. And so part of my job is to point out the strengths and weaknesses of cases. And I would never do that jointly, but in caucus, yes, I have to take them and bring them back to reality. That is my job.
Okay. I'm going to...
Wait, do any of my colleagues disagree on that?
What I would say is...
I've already asked Mark. Mark, if you unmute yourself, ask your question.
First of all, I thought you guys did a phenomenal job of doing this. Suzanne, your eye rolls are amazing.
I agree.
Doing this, you were so expressive. Actually, my question is related to the fact that Suzanne's eyes were rolling back. Her ability to hire Michelle after the fact, and it to be, I could see her terminating Michelle shortly after the employment situation because she was still so upset with her. And Felicia, you're going back saying very promisingly, oh, they're willing to accept you back, when they weren't really willing to accept her back. They were just appeasement. And I'm wondering, is that something you consider actually resolving that piece, or do you just try and get the settlement?
That came from her attorney. Her attorney is the one that conveyed that offer. And I don't know if you got to see our first mediation session. This is actually a continuation of that fact scenario. And Suzanne did voluntarily in that say that she was a good employee. And yes, she would have her back without the eye rolls. So we're building upon that.
But and again, I didn't see the first part. I just saw the second. I just didn't think that her coming back and being successful in that situation was a given.
That's true, but that's why we said work remotely. Don't come back to the office, stay at home. I mean, the offer, I think, was awesome. We're not just increasing it, we're doubling the percentage. We're doubling the amount of money she's getting back. When she goes at not 1%, it's 2%. So she's getting twice as much the percentage of everything she sells. She's working from home. She's got everything she needs, and she's out of my client's hair. She makes money, great. She doesn't make money, not a problem.
I think your position was very good.
The difference from the first one was that Michelle was pro se the first time, and then when her attorney came in, it gave it a much different tone.
Okay, Jay? Jay, unmute
Okay.
yourself.
You hear me now?
Yes.
Okay, good. So it was quite stimulating, this mediation, but I do have certain questions. For example, Andrew, you were coming in for the first time, but you made a point of saying you had not deposed the bookkeeper. I don't know to what extent the bookkeeper would have added or not added to your case for presentation at this point, but it would seem to me you might have spoken to her before this meeting just to get a sense of where she stood so that you had potentially some ammunition to bring into your client's side. Number one. Number two, what happened to the customers that Michelle had been servicing? She stopped working for you, Susan. So what happened to those customers? Were they reassigned and is she starting over from zero then? So that you have to consider as well in your potential offers. And in terms of the fact that, Michelle, you lost your father, I understand that was a terrible situation, but was he contributing to the maintenance of your family? I mean, why should you pay? Because you couldn't, at least initially.
That was in the first. Those facts came out in the first.
I remember they came out in the first. And
she watched my son. She watched my disabled son, took him off the school bus and things like that, and did contribute to the family.
Okay. And Jay, just regarding the bookkeeper, if I had said I'd deposed, that probably would have been a smoking gun. So in order to keep the fact pattern as real to what it was, that's why I kept that door open. That, and also with respect to mediation, the point is to save money up front rather than go through the
well, I'm not saying depose it in the formal sense. I'm just having a brief conversation to get an idea of what she might have been able to add to your side had you needed to bring her in, and you had something to bring into the conversation, to the mediation.
Good point.
So are there any other questions from our members? So let me go back now to Felicia. In fact, everyone can chime in on this one. How far do you think it is appropriate for the the mediator to be making evaluations as to the outcome, as opposed to raising questions about the soundness of their case? So you could do it in two different ways. One is you can ask questions. You can say, well, COVID is everywhere. How would you think you'd be able to prove that they got the COVID from? That's a question, as opposed to you have a very hard case to prove, which is the conclusion.
What I normally do is I don't tell them you have a bad or whatever. I just push back. Have you really considered this point? What are your thoughts about this point? I take more of a question viewpoint just to get them in a reflective mode. Also, I also go through a coaching process, which is I ask them questions. Have you considered this? Have you considered that? What are your thoughts about this? So I put those things out there for them to come to their own conclusion based on what I said. And if they can convince me, and not necessarily convince me per se, but if they give me a good argument back, then I'm more comfortable with taking their position back to the other side and vice versa.
Anyone, any other comments about that?
I think the first thing you do is ask the question and then listen to the answer and then respond based upon what the answer is. If the answer is going to be, oh, I'll have no trouble, then you go, well, I don't know. How are you going to do that? I think that the best way to get somebody to a position is have them answer the question in their own minds so that they come to the conclusion you want them to come to. You know how difficult it is. You know how hard it's going to be. I have had the opportunity to speak to juries in my past life, and there's no better witness that when the jury is asked, how'd you come to that conclusion? The answer is not because of the witness's testimony per se, if it's an expert in particular, but because, well, that's the way I feel about it. If you can get the person to really believe it in their heart that, gee, there might be a problem, it's going to be successful regardless of how you do it. But if you just tell them, it's going to be like water off a duck's back sometimes. I think you have to listen very attentively to what the person is saying, how they're responding, and then take it down the road, which will enable them to see the logic in whatever position you're trying to get them to understand. It's got to be them. They've got to see the difficulty. You can't tell them, you try, you can say it 5, 6, 7 times, but until they sit back and go, you know what, there may be an issue here, they're not going to accept it.
Exactly, Brad, exactly. And that's why I started that with Michelle, trying to get her when she's like, I'm definitely going to win. Common sense is that I'm going to win. So if I had the time, I would have continued down that process. Yeah. And the same with Andrew, with the attorney. I would never, tell them, like you can't win this case. I would be asking questions about how he was going to go about proving it. But I had to circumvent all that and cut to the chase so that we could, move them off of their millions and we had like 60 seconds left to try and get him to come back with a demand. So.
Okay, we have a question from Jerry Scola. Jerry, are you there? You have to unmute yourself.
There you go.
Okay, can you hear me?
Yes.
I think that I would not go back with the $100,000. They were too far apart. That was never going to fly, no matter what. I would have tried to move the number up before I would have gone back in.
Thank you, Jerry. What we did here, just to fill you in, is we tried to accelerate this process and go from our first mediation to skip over the next 6 hours and get our audience to a wrap up where you could pretend that we went through all of those discussions going back and forth with the numbers. So obviously it didn't really work well when, Suzanne came back with that 100 because we're skipping over all those hours and the process in there. So it was unrealistic. And that was our aim, is to try and leave, everybody watching with some type of, being close to a resolution rather than, here we are nowhere, millions and zero. So that's what we were trying to do.
I have a question for Brad. Suzanne said, if I start at 200, they'll want more.
Correct. Mm-hmm.
If I started at 100, then, I can always go, essentially, I can always go up. What's wrong with that philosophy?
I don't think anything. In fact, I was going to raise my hand, so to speak, and say, Jerry, the issue that you bring up is one of lowballing. What do you do, or how do you approach coming in with a number that you know is absolutely untenable, but doing it for the purpose of saying to the other person, that's your first offer. Your first offer was $10 million. You want to be reasonable? Let's be reasonable. I think you're correct in a sense that $100,000 would not settle this case, but neither would $3 million. So the question is, where do you come in? And when we do this stuff, when we have people from insurance companies coming in, and a lawyer wants the other person to go back and forth, so they started at $500,000 and $250,000. For some reason, they think that means it's going to be right in the middle. How do you approach that in a way that says to the folks, no, the $500,000 is the reasonable offer, not the $750,000, and that leads sometimes mediators to take positions that they know are not tenable, but just for purposes of setting some ground rules of you could get zero, so let's get it down to a reasonable number. So yeah, part of it is exactly what Felicia was saying in terms of we had to condense it a lot. But if I were representing Suzanne in a real mediation, I would come in at zero. And it would come in as a part-time worker, and the final offer would be in saving some money from the deductible. Deductible's $250,000. If I don't save her any money, I'm not doing any good. My insurance company's gonna have to pay for it. So I needed to save her money from the $250,000, which is why the top offer was $200,000. And then what can I give to the other to the employee that will give her something? And I figured, well, let's give her a job back, plus more money, plus she can work at home, plus her insurance. And I would as Felicia did, I would say, look what you're getting. My goodness, you're getting back to work. You're getting more money. You're getting to work from home. You're getting your insurance back. What do you want? And you're geting money. You don't take the risk of getting nothing. As a mediator, I like to be real excited about offers being made when I present them, because I want to put the most favorable light on it, the most favorable inferences in it, so that people, when they're listening to me, even though they may not want it, they can see my excitement about it. This can really work. This can really get you something. Look how successful you are. It doesn't always work, but I think that sometimes putting the best spin on things from a mediator's perspective is important. And maybe when you start lower, Carl, when you start at the zero, or you started, I'll give you $12, it makes it a lot easier to say, look how well you're doing. We started at nothing, and look at all we're giving you, and you don't have to risk everything.
I had a question for Felicia, because she immediately said, Felicia said to them, well, this is the offer, but there's room movement in that. And I was kind of like, wait.
Yeah, that's because we had about 10 seconds. We had about 10 seconds left at that time.
I'm just curious, I know you were trying to move it along, but I just was trying to.
Okay, so reality is I would never volunteer that. That would be a question that the attorneys or the parties would ask me, is there any movement? And then I would be left to say yes or no. I wouldn't come in and just say, yeah, here's the offer, but there's a lot of movement. Unless that was the message that they wanted me to. Sometimes that is the message that I am asked to deliver, but otherwise, not voluntarily.
Well,
again, just to everybody, I just have to put that caveat out there. So much of what I did, especially the last 10 minutes, was just to get this going on the accelerated plan and looking like that $100,000 that wasn't supposed to be the starting point. We were trying to get to the ending point. Brad got it. That's why he came in with the final offer, because we had been negotiating with 0 and $1 million and 10 and 300, and we had gotten to that point. But yeah, it got lost there.
Just a brief comment on what Felicia is saying. She's totally correct. We actually had a conclusion on the table. Unfortunately, we never reached that because the dynamic somewhat changed, but she's right on point. She was really put under the gun that she had to play multiple roles, be the facilitator and also be the timekeeper. And she kept trying to push things along. And I may have thrown in a few things, and Brad may have thrown in a few things, Susie may have thrown in a few things with the eyes, and Michelle. So she did a great job keeping us on target.
Okay, that is the end of our mediation. We're over 1 o'clock. I want to thank everybody. I thought you were all great. Absolutely.
thanks.
This was very realistic.
Thank you.
And I thought you all did a wonderful job. And I look forward to doing this again next month with a different fact pattern. But I think they're very, very useful. And I thought you're all wonderful. So have a great day. And next week is Tech Time with Lawrence and Carl. And the following week is we're going to do our mock divorce mediation. So everyone, please come on back. Have a great week.
Thank you. Thank you for putting it
Thank you,
together. Thank you
everybody.
all. It was a lot of fun.